Hey everyone, and welcome to a new Bederow letter filed to the Commonwealth. Bederow, as we all know, is one of the best things that have come out of the Karen Read / Aidan Kearney cases. This man has a way with words that makes it really fun to be a YouTube grifter and reading what he is writing about. The letter today pertains to on numerous outstanding specific Brady, Gigolo, and Rule 14 demands from October 8th and 17th, 2024. It relates in relevant parts to Catherine Peter, also famously known around the interwebs as Krusty Panties. I don't know if she had this letter yesterday, because all of a sudden, Krusty started crying on Twitwat. She claimed that if anything happened to her, they should look into Aidan or Karen. Krusty, I hate to break your grifting bottle, but no one finds you near interesting enough or dangerous enough that they want to do anything to you. You are a middle-aged woman who has no life. All you do is sit online, complain about Aidan. You are not that important. No one would do anything to you. We laugh our ace off and call you Krusty Panties. Do you really think that Aidan will send some sicarios out to get you? But again, all your little smurfs, I can see them in my comments. They'll come by and tell me that we are the worst people in the world, while you constantly sit online and harass people. Shouldn't you be more worried about all the lawsuits you have racked up under your belt than crying on Twitwat and trying to imply that anyone would even do anything to you? But again, perpetual victimhood seems to be your state of mind. Back to Bederow. Pertaining to Karen Peters, who on information and belief assisted the Commonwealth's investigation and prosecution of Aidan Kearney and Karen Read as part of her intertwined relationship with the Commonwealth and several witnesses against them. As detailed in the October 8th demand, Ms. Peters, motivated by her obsessive hatred of Mr. Kearney, which she exhibits daily on social media, immersed herself into the Kearney and Read matters with the blessing of the Commonwealth. Probably not the smartest move by the Commonwealth to try and fight a social media campaign with people who are so filled with hatred that they will do and say almost anything just to try and win. Kind of like implying someone would hurt them on behest of either Aidan or Karen. No one cares enough about you. But you can be a big problem for the Commonwealth right now. Although these specific demands were made more than 5 months ago, you have neither disclosed any information or materials in a response to them, nor represented to Mr. Kearney's defense team that there is no such evidence existing. In the interest of avoiding pointless litigation and an unnecessary waste of court resources, I respectfully request a formal response to this demand within 2 weeks. One thing is, they didn't turn over anything, but they didn't send a letter saying, well, Krusty had nothing to do with the Commonwealth. That could have saved them a whole lot. So, absence of evidence can be evidence. Effective March 1st, 2025, an amendment to Rule 14 of the Massachusetts Rule of Criminal Procedure expanded the Commonwealth's duty to investigate whether there is any discoverable evidence within the possession, custody, and control of the prosecution team, and to then promptly disclose it. See Rule 14. Under the new rule, the prosecution team expressly includes all persons under the prosecuting officer's direction and control. This is the thing that I have mentioned multiple times, where they say, well, Proctor was the guy who did it. We had nothing to do with it, so it's not a Rule 14 violation. Well, according to the rules, it is. And remember, it's a new trial. So since March 1st, everything should be kicked over or seen as a Rule 14 violation. I'm not sure Bev got this memo yet. Under the new rule, you are now required to inform every member of the prosecution team who you have reason to believe may be in possession of items or information subject to discovery about the obligation of this rule, and then inquire of each as to the existence of any such items or information. Prior to March 1st, you were obligated at a minimum to question Kenneth Mello, Massachusetts State Police members, John Fanning and Brian Tolley and Miss Peter, as part of your obligation to learn about the existence of any discoverable evidence. Rule 14 now requires you to inquire of each member of the Reed prosecution team for the existence of discoverable information and material, given A, both cases are under the direction and control of the Norfolk County District Attorney. 2, the subject matter of Mr. Kearney's case overlaps with Mrs. Reed's case. C, both cases involve the same MSP investigation, Fanning and Tolley. The Reed prosecution team says close relationship with numerous witnesses who will testify against Mr. Kearney. And E, the Reed prosecution team team's clear interest in and relevant intervention into Mr. Kearney's case. Consequently, any discoverable information and material in the Commonwealth's possession, custody, and control, whether the Kearney or Reed prosecution team, related to Miss Peters' involvement with the Commonwealth and all witnesses who will testify against Mr. Kearney, must be collected and promptly disclosed to his defense. Prosecutor's obligation to collect and disclose discoverable information includes all items and information in possession, custody, or control of the prosecuting office. This, of course, includes prompt disclosure of any evidence that the Reed prosecution team has in their possession, custody, or control, which adversely impacts the credibility of any witness against Mr. Kearney, otherwise favor him or cast doubt on the case against him. The Reed prosecution team has sought information from you about Mr. Kearney to use as conscience of guilt evidence against Ms. Reed. They have included Mr. Kearney on their witness list against Ms. Reed, despite seeking judicial approval to access Mr. Kearney's cellular phones under Rule 17. Lead prosecutor Hank Brennan nevertheless has expressed his belief that he has an absolute right to access evidence against Mr. Kearney without judicial intervention. Well, the judge didn't agree, Mr. Brennan. Mr. Brennan and you have implied that counsel for Ms. Reed and Mr. Kearney assisted in, or at least condoned, a conspiracy between Ms. Reed and Mr. Kearney to intimidate witnesses scheduled to testify against them, although a grand jury refused to indict Ms. Reed. That's a little mistake. And Mr. Kearney for allegedly conspiring to commit witness intimidation. You noted in a March 20th, 2025 filing that the Commonwealth's investigation remains open. In response to Ms. Reed's request that I join her defense team, Mr. Brennan recklessly and inaccurately suggested, without stating his purported source of information, to the court that I shared protected material to mutually benefit Ms. Reed and Mr. Kearney. Another little misstatement by Hanky Panky. Clearly, Bederow is too smart for that. He doesn't share stuff. He can't put up, even though Hanky Panky doesn't have that ability, I trust Bederow is smart enough that he would never do this. But Hank, he doesn't care. He'll let anything fly in the courtroom because Beveridge will never hold it against him. Look how weak he was in front of a new judge. He knows Beveridge will do whatever she can to help him. As I said earlier, she's sitting on the scale of justice. She's not even just tipping it. Your disclosure obligation to Mr. Kearney remains irrespective of your view or that of the Reed prosecution team of the evidence reliability, credibility, or admissibility, and without regard to whether the information has been documented in any manner. In other words, where the subject matter is discoverable, you must promptly disclose any information derived from conversations or interviews between or among Miss Peter, the relevant witnesses against Mr. Kearney, and any members of the Kearney and Reed prosecution team, even if it was not memorialized in any way. As evidenced by the October 8th and 17th demands, there can be no doubt that the Commonwealth has in its possession, custody and control, discoverable material related to Miss Peters' involvement in the case against Mr. Kearney. Lieutenant Fanning has sworn to an unnamed civilian, Miss Peters, provided the MSP redacted and redacted, that the MSP redacted. Miss Peters has admitted under oath that she has been cooperating with the prosecution and giving them information on Mr. Kearney. She has boasted under oath that Mr. Kearney should blame her for his legal issues because I am furnishing information against him. See audio recording of Kearney v. Peter, March 11th, Leominster District Court docket, blah, blah, blah. She has described herself as a potential witness against Mr. Kearney and acknowledged meeting with Mr. Mello on the same day Mr. Kearney was arraigned for allegedly intimidating several witnesses against Miss Reed. The Norfolk DA's office has recused itself from prosecuting at least 2 witness intimidations against Miss Peters, in which she is the defendant. Miss Peters and blah, 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 that Mr. Kearney apparently failed to recognize that the Norfolk's DA office recused itself from prosecuting Miss Peters because she was blah, blah, blah. Within 1 hour of Mr. Kearney's October 11th arrest and seizure of his phones by MSP Detective Lieutenant Tully, Miss Peter announced on X that we knew about alleged witness intimidation of Reed witnesses by one of her attorneys. She strongly implied that she had seen text messages to support this absurd claim. Miss Peters' own text messages, redacted, confirmed that she leveraged her direct access to Mr. Mello and the MSP to help the Commonwealth's prosecution of Mr. Kearney. She told redacted that she would redacted about Mr. Kearney's alleged crimes. Miss Peters has bragged about her close relationship with and access to redacted. In these circumstances, it's hard to fathom how the Commonwealth could not be in possession, custody, or control of discoverable information and materials referenced in the October 8 and 17 demands. To be clear, we demand any and all information and materials subject to disclosure under Brady, Gigolo, or Rule 14, including but not limited to evidence of Miss Peters' involvement in the Kearney and Reed cases, and evidence of interactions and communications, including their substance, between and among Miss Peter, the Kearney prosecution team, the Reed prosecution team, and Reed case witnesses who are also expected to testify against Mr. Kearney, included but not limited to Jen McCabe, Matt McCabe, Brian Albert, Nicole Albert, Chris Albert, Julie Nagel, Colin Albert, Michael Proctor, and Julie Nagel. Pursuant to Rule 14, both prosecution teams are under a continuing obligation to promptly disclose any information and material subject to disclosure under Rule 14. So, a nice Sunday letter to start the day with from the wonderful Mark Bederow. I believe he will be on the Young Jerks later today. Did the Commonwealth F up again? In their haste to try and pin it on the girl, and when Aidan brought knowledge about this case to the wider public, they started attacking Aidan as well. But the problem is, if you're playing with pigs, you will get dirty. Will the downfall of all of these special prosecutors be that they build their case against people on crusty panties? A woman who have kept talking on Twit about all her special knowledge, all her evidence, all the evidence she has seen, all her connections. We know from the LG case that they had special access to the MSP. I still claim it was a honeypot setup that got Aidan in prison the first time. It seems like the Commonwealth are not that willing to do what they should do, which is turn over the evidence that they are in contact with Krusty. And I know to all of you Smurfs who will now attack me again in my comment sections because you can't talk about Krusty, you can't talk about Plevin, they are gods to you. If there's nothing there, then either under the penalty of perjury, write an affidavit saying we have no connections to Krusty Panties, never had, never will, or turn over all the stuff you have. Doing nothing doesn't work in the legal system. This isn't one of Higgins' hookup attempts where they ghost him. You can't ghost a lawyer. All of you Smurfs who want to tell me how big of an asshole I am, I already know. You don't have to waste it. But thank you for doing it. All the engagement work. And I'll put you on Twit just to make all of us laugh. And Krusty, no one cares about you. No one's going to hurt you. Don't try and make yourself into a victim. You couldn't get your fat ass fast enough connected to this trial so you could get some relevance because you hate Aidan. How's that paying off now?